Hi, my name is Wendell Norkia and I teach at the University of the Western Cape, Faculty of Law, and specifically at the Department of Criminal Justice and Procedure. This video will specifically look at bail proceedings in South Africa, very briefly, and what you need to know in terms of how bail proceedings work in our criminal courts. So to start off, I think it's important to look at what the meaning of bail is. And bail is there to ensure that the accused attends his trial. I will refer to the accused as a male. And then this means that the accused, when they are detained, they need to then pay an amount of money or a guarantee to the state to ensure that they are then released and then return for their trial date. The payment of bail money is basically a deposit. So if you pay the money, you attend your trial, you will get the money back. So in terms of bail proceedings, it's also regulated by the Constitution. In terms of, when you look at your Constitution, you will see in section 351F, it specifically refers to bail, and it states that every accused has the right to be released from detention if the interest of justice permits, subject to reasonable conditions. So there is a constitutional right for an accused to be released on bail, and of course this will happen during the trial, especially if it's a court bail process, a more serious crime that has been committed, which will then be subject to a court bail procedure. Then it is up to the court to decide whether it is in the interest of justice actually to release the accused on bail. So there are three forms of bail, very briefly. There's police bail, prosecutorial bail, and then court bail, which I will focus on, mainly court bail. So police bail and prosecutorial bail are mainly for minor crimes, more so police bail, and then prosecutorial bail deals with more serious crimes. But court bail will be your most serious crimes, and it will be a hearing in a court. It is not a criminal procedure, but it falls under criminal procedure because we're dealing here with crimes, the commission of crimes. So it's important to understand also that bail proceedings are not about punishing the accused. So if the accused is not granted bail, it doesn't mean that we are punishing the accused, but we as the court then believe that it is in the interest of justice to keep this person, the accused, in detention. And there are various reasons for this, or factors that the court will take into consideration to determine whether it's in the interest of justice to release a person or not. These factors are included in section 60, subsection 4A, 64A, in the Criminal Procedure Act. So bail is regulated mainly by the Constitution, as it is the supreme law in South Africa, and then also the Criminal Procedure Act. The Criminal Procedure Act, as well as the Constitution, are both available online, and you can simply just Google Constitution and Criminal Procedure Act 51 of 1977, and you should be able to get them online. All the schedules are also included at the back of the Criminal Procedure Act. When you talk about the crimes that are included in the schedules, for example, Schedule 1, 2, up until 7, and these are important when we talk about specific serious crimes, which will also play a role in determining whether a person should be released on bail or not. In terms of the Constitution, it is not only section 35(1)(f) that is important. There is also section 10, which refers to human dignity. There's section 12, which refers to security of the person. There are many other rights that are also important in terms of when a person is released on bail or not, because you're dealing here with a person, very importantly, who has not been found guilty of a crime yet. So the presumption of innocence, which is also included in section 35 of the accused rights, that's also very important to understand that once we are dealing with a bail proceeding, it's only looking at whether this person poses a danger to society or whether this person will flee from his criminal trial, and not about whether the person is guilty or not, because the state is still conducting the investigation. In South Africa, the police will still investigate, and then National Prosecuting Authority will will conclude their investigation and look at all the evidence in the police docket and then decide whether they actually then want to pursue with the case or not. But this bail looks at the very initial stages of an accused and his interaction with the state and the criminal justice system, because you're dealing here with someone who has been arrested, and then within 48 hours that person then needs to appear before the court, and during that process it's also important then to decide whether the person should be released on bail or not. There's also various other sections which we will not go into, which deals with whether we can also postpone proceedings, and we can, but I will not be dealing with those proceedings. So in terms of bail, very importantly, and the main factors that a court will consider whether a person should be granted bail or not is the following. So they are included in section 60, subsection 4A, and there are 5 factors which you need to be aware of. So the first one, which will be subsection 4A or 64A, states the following: where there is the likelihood that the accused, if he or she were released on bail, will endanger the safety of the public, any person against whom the offence in question was allegedly committed, or any other particular person, or will commit a Schedule 1 offence. So this specific factor asks the question, is it in the interest of justice for us to release an accused on bail, to release him from detention, if there's a likelihood or possibility if this person will actually then cause more harm in the community, or will commit a very serious offense, or will just continue on his merry way of committing crimes, then it's obviously not in the interest of justice to release this person if we believe as the court that this person will commit further crime. Then of course you have the two parties during this bail proceeding. You have the state, the prosecutor, and then you also have the defense attorney or the advocate who will be representing the accused. And of course, the state will always argue that, yes, if they oppose bail, because sometimes the state can also decide not to oppose bail because it's simply not a very serious crime, or they believe it's not necessary for them to oppose bail, but they must give reasons for that as well. But in terms of section 64A, it's then important for the state to prove to the court that this person could possibly commit further crime in the future. So that's the first factor that a court will look at. Then we also have section 64B, and by the way, again, this is the Criminal Procedure Act. It's all included in the Criminal Procedure Act. This specific factor looks at where there is the likelihood that the accused, if he or she were released on bail, will attempt to evade his or her trial. So this is, in short, a flight risk. This means that it is not in the interest of justice to release the accused on bail if we believe that there's a possibility that he can flee, that he will run away. So this deals with the typical flight risk. The state will look at whether the accused has a passport, whether the accused has property overseas, whether the accused travels regularly. And we've seen this in the past, where accused have been released on bail and then they just flee. They go to various other countries and we can never find them again. Perhaps only after 5-6 years we find the accused somewhere in another country, and we're able to arrest that person just because there's been good investigation done between the two countries, and that person is then extradited back from that country to South Africa, and we're then able to prosecute that person. That is a very important factor that will be considered by the court during a bail proceeding. Then very importantly, subsection 4C refers to where there's a likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. So it will not be in the interest of justice if we believe as the state, and then eventually as the court, because the court must make the decision in terms of bail, whether the court believes that this individual, the accused, will actually destroy evidence because he might have hidden something that relates to the crime, or he knows where one of the body parts, for example, have been buried, and he is intimidating some of the witnesses that are involved in the case. He has maybe threatened maybe the deceased mother or sister or brother, and that evidence is then led in court, and then the court believes that there's a high likelihood that the accused will intimidate witnesses or destroy evidence. That is a very important factor. And if the court has that evidence and believes that is true, on a balance of probabilities, because that is the standard of proof in a bail proceeding, not beyond a reasonable doubt, that is for a criminal trial. So if a court believes that there's a likelihood that he will destroy evidence or conceal evidence or intimidate witnesses, the court will not grant bail. Then D refers to where there's a likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives of the proper functioning of the criminal justice system. And again, the court will have to determine whether this is possibly true, and the state will lead evidence, for example, that the accused has a history of lying to the police or to the courts, and he has a history of undermining the criminal justice system. He's not cooperating with the police always. And then the state can lead this evidence to show that it's better to detain this person and not to release him on bail, because he can be a threat to the proper functioning of the justice system. Then lastly is where in exceptional circumstances there is a likelihood that the release of the accused will disturb the public order or undermine the public peace or security. So in South Africa, unfortunately, we have a lot of gender-based violence. And if we, for example, have an accused who has been charged with murder and also, for example, rape, and maybe even more than one person, maybe there's 2 or 3 victims involved, and the community has become aware of this, and let's say they picket outside the court every day, or they also have their placards and they protest outside the court for this person to be hanged, or this person to be kept in prison, not to be granted bail, no bail. You might see these protesters outside our courts on a daily basis, and they are protesting against bail. They want bail to be denied. This is what this specific factor does refer to, because if we release the accused on bail, there's a high likelihood that will undermine public order or disturb public order. And what might actually also happen is mob justice or vigilante justice might also take place, which means that the accused can actually be murdered by the community, because they know or they believe he has committed the crimes, because the state has charged him with those crimes, and they believe that it's better for them to then murder the person, which of course is also wrong. Vigilante justice and mob justice is a crime. But of course, sometimes the community becomes very passionate and very emotional, and they believe that they need to take justice into their own hands. And that's why, as a safeguard, this specific factor also looks at the interests of the accused as well, and well, the best interest, I would say, of the accused. So that, in a nutshell, is the bail proceedings in South Africa. So the court will look at those 5 factors. The state only has to prove one of those factors. They'll look at all the factors, but if they can put one of those factors to the court and be very strong in their arguments in terms of that this accused will flee or this accused will intimidate witnesses, the court will most likely not grant bail to the accused. Then there's also something that I need to mention in terms of the seriousness of crimes. If you commit a very serious crime like premeditated murder, in South Africa we call it premeditated murder or planned murder, one of the most serious murders, you will have to prove as the accused that you should be released on bail, and that there are exceptional circumstances for you to be released on bail. This can be that you have a serious disease. This can be that you have a very small child at home, and there are various other factors. Giving the court the reasons, or you giving the reasons to the court as to why you should be released on bail. Then, in terms of a less serious crime, in terms of Schedule 5 offenses, for example, murder, where you simply, for example, stab a person in the street and you run away, and you didn't plan the murder. It's a straightforward murder. You will have to then prove it is in the interest of justice for you to be released on bail. And again, you will then have to refer to the factors in Schedule or Section 60, subsection 4A to E, prove those factors to the court. So what's interesting about these Schedule 5 and Schedule 6 offences, if the accused are charged with them, there's a reverse burden of proof, a reverse onus on the accused to all of a sudden prove that he needs to be released on bail. Whereas with other crimes, less serious crimes, there is no burden of proof on the accused, but the state has to prove that the accused needs to be kept in prison, needs to be detained, and then the defense attorney will simply just also give evidence to court as to why he or she believes that the accused should not be kept in detention. And so that is basically what bail proceedings are in South Africa, very briefly. And I hope this helps you. And if you have any other questions, please drop a comment in the comment section. Thank you and all of the best. Bye.